The U.S. Supreme Court could be facing a decision on same-sex marriage. It all stems from one woman's case. You may recall back in 2015, Kim Davis was a county clerk in Kentucky who was jailed for refusing to issue marriage licenses to gay couples on religious grounds. She's appealing that ruling to the U.S. Supreme Court and in turn also asking the justices to overturn a 2015 ruling that legalized same-sex marriage. I spoke with a legal expert for some insight on this case. I'm joined by Dr. Deirdre Bowen, a law professor with Seattle University. Thank you for taking the time today.
My pleasure.
So, Professor, the lower courts have dismissed the former Kentucky clerk's case on this. She ultimately wants the U.S. Supreme Court to overturn same-sex marriage. But the question is, what is the real likelihood that the U.S. Supreme Court will even hear her case?
That's a challenging question because there actually is a likelihood that the Supreme Court will hear this case. The complicating factor is there's multiple parts to the case. So the question is, what parts of the case will they hear?
What are the parts?
Okay, so the two parts are she has a main personal claim that says I should not have been sued for emotional damages under what's called a tort claim because I should have immunity as a state actor, or if I don't have immunity because I was acting as a state actor, I should have protections as an individual who gets to practice their First Amendment rights. That's really the bulk of what this claim is about. The part that's getting the most attention is the part that you have asked about, which is overturning Obergefell, which is the same-sex marriage case. And it's very likely that the court could decide to hear the case on just those tort claims and not touch the same-sex marriage case. The issue is this. There's going to be great temptation with this court to want to go back to pre-Obergefell, similar to what Dobbs did, which is let the states decide what marriage will look like.
Yeah, you say that it might be some attraction. Are you saying that because it's a conservative majority?
Yes, exactly. So if you look at what the dissenting opinion was in the Obergefell case, which is the one that ruled same-sex marriage is a fundamental right, meaning it's like a super constitutional right. The dissenting justices made very clear that they thought this was a legal fiction. It was made up out of whole cloth. The way that they engage in their legal analysis is to say if it's not literally written in the Constitution, it's not a right that exists. And when you take that in combination with what happened with the Dobbs decision, which is about overturning the right to abortion, those cases come from this same thread of legal theory, which is called substantive due process rights, which I know sounds very complicated. But basically it's saying we have liberty rights and that the state can't interfere with those rights and that they should be interpreted beyond the literal words of the Constitution. And this conservative court made clear in Dobbs part of the reason why they overturned the right to an abortion is to say those rights don't exist in the Constitution, therefore they're a legal fiction, and we're no longer going to acknowledge them. We need to correct the mistake. That's the temptation.
Yeah, and it flipped it back to the states, the issue. So again, a lot to see, a lot to weigh here. Thank you so much for your time on weighing on this issue today.
Oh, it's my pleasure.
The Supreme Court is expected to consider the case during a September 29th judges conference. So a decision on whether or not they will take up the case could come in early October.